Well, here I am again. Got a little Pink Floyd, Shine On You Crazy Diamond playing in the background. We'll see how this goes. Alright, got my PowerPoint up on my computer, which is projecting through my projector, and which is playing behind me in the background. So let's do it. Let's try it. Why not? Alright, let's go. We talked about we started off with the arrest, right? That's the first part of the criminal trial, as opposed to the pleadings of the civil trial, right? We talked about warrants and when the police can come in, when they can't come in, when they can search, when they can't search, those kinds of things. But for right now, we're going to assume that there has been an arrest. So what happens after you are arrested? Well, it depends on the severity of the crime, really. Sometimes they might, knock on the door of the judge and say you're needed at the courthouse. If a person is caught, say, committing a murder or something, or something heinous, they might want to get the judge right in there right away and take care of business that way. Typically, most crimes don't work out that way. Maybe they're a lesser crime, maybe they're a less serious felony, or whatever. We're going to kind of focus on what happens there, right? It's part of your due process, right? Part of your due process is the right to a fair, speedy trial. And so this is where it starts, really, when you are arrested. So what happens when you are arrested? Soon after you are arrested, you'll be brought before a judge. You'll be informed of the nature of the complaint. You'll be made aware of your rights if you haven't been already. And sometimes here bail is even set. This is where it gets a little bit sketchy, though, because with bail reform now being a thing, you might just be, chances are, unless it's one of those heinous crimes we were talking about, or serious personal injury, or crime against a child or something like that that's very serious, you will probably just be let go with no bail set. And we talked about the advantages and disadvantages of that as well, right? But that's kind of what's going to happen. The bottom here. If the judge finds that there's probable cause that a crime's been committed, your case will be referred to a prosecuting attorney. I got a picture of him over there. Right? That's the dude whose job it is to put all the evidence against you to, put you away, make sure justice is served for the rights of the people. Right? So your case will be referred to the prosecuting attorney. Your prosecuting attorney's job then is to prepare something called an information. That's the legal term. He prepares an information. You can kind of compare the information piece here to the discovery phase of the civil trial, right? He's putting the pieces together of the is what he's doing here. He's building evidence against you, right? He's beginning to build his case. And that information is your final, is your formal, let's see if I can get this to show up on there. It's a set of formal charges that the prosecuting attorney is going to turn over to the grand jury, right? And we're going to talk a little bit more about grand juries in a minute. So you've been arrested. The prosecuting attorney has been assigned to your case. The prosecuting attorney is then preparing an information, which is the list of formal charges to present to the grand jury. And this might be where the arraignment happens. Here's the problem. We'll get to this in a second. Here's the problem. What's happened in our criminal justice system is after you've been arrested, maybe you're brought before a judge, and then maybe bail is set. You can't post bail, and you go to jail, right? You await your arraignment in jail, right? And sometimes, depending on where you are, that could be an extended period of time. That could be weeks, months, whatever the case may be, depending on where you are. Some places, like in city jails, like in Albany City Jail, they try to get you turned around right away in your arraignment, right? So this is what happens at your arraignment. You show up when you're supposed to show up, right? You're standing before the judge with your attorney that's one's either been appointed to you or will be appointed to you, or one that you've hired. So you're standing before the judge, and the judge is going to simply ask you what you plea. How do you plea in this case? He'll say, all right, these are the charges against you as prepared in the information. You've been accused of this, this, and this. How do you plea? Right? And the judge doesn't really want any kind of long explanation. This is a quick thing. He doesn't want to be like, well, Your Honor, this is kind of what happened. The judge is going to say, no. How do you plead? Do you plead guilty or not guilty? And of course, if you don't know what the heck is going on in this case, and you don't have a lawyer, you'll definitely have one now. All right, because one will be appointed to you at this time. If you plead guilty here, well, then you go into sentencing. All right, then the judge will, in a later date, will sentence you and punish you for what you just admitted to. If you plead not guilty, then we're going to start the trial. Right? And here's the other piece of bail reform too. Judges are busy. Courtrooms are busy. So this is the argument with bail reform, right? If from the time you are arrested to the time your trial actually starts after you plead not guilty, well, then that could be an extended period of time. So this is where this bail reform came from. Those people who can afford bail, those people who can afford an attorney, can go home with their families at this time, right? Those people who can't are going to sit in jail, right? They're going to sit in county. And, what's fair? Is that fair? I don't know. I mean, I don't think that's fair. Maybe there does need to be some reform, right? And that's the argument we've been making, but maybe not quite the extent that it was. But, that's up for debate.